So there's an unfortunate case going on right now out of, I believe, Denver, where a 10-year-old girl fell off of a roller coaster and unfortunately passed away. I believe she fell about 100 feet. What I'm hearing a lot of from people is what they're reading in the news, and that's, oh, well, the family signed a waiver. So I want to talk about waivers real quick because we hear a lot about that. That's a very common defense in these situations. Companies, corporations, whoever's running a festival, they'll a lot of times have you sign a waiver. Waivers speak to known and unknown dangers. They're trying to protect themselves. It's just good business. It basically says, hey, if you get hurt in any one of these ways, we're just making you aware of this now so you can't sue us later. And I fully understand that. These are negligence cases though, guys, right? And you're claiming that somebody was unreasonable when they were negligent. They acted out of the scope of ordinary reasonability. For this reason, if I'm claiming negligence, you can't go ahead and say, oh, well, you signed a waiver that said that if we acted unreasonably and did something stupid or out of the ordinary, that we wouldn't be liable. That's not going to hold up in contract law. It definitely won't hold up in the state of Arizona. Let me give you an example. I had a client that went to a fall event, and basically it was you go out on these mats and you kind of play fight each other, kind of like American Gladiator, you know, kind of back and forth, and you put on these big puffy suits and you go out on this little bridge. Unfortunately, she was not supplied the proper headgear. You're actually supposed to wear this huge kind of comically looking helmet thing to protect you in case you fell or got hit in the head. They gave the contestants all of the pads. They didn't give them these. Unfortunately, she did fall. She suffered a major concussion and incurred a lot of medical expenses over the next couple of years. Immediately, that company came out and said, well, she signed a waiver. We're not responsible. We looked right past that waiver because what they had done was negligent. You had not given her the proper padding. How would my client have known that you were supposed to need headgear and that the mat was hard enough to give you a concussion? You wouldn't assume that. You would assume that the people running the event would give you the proper equipment, but unfortunately they didn't. So in this case in Denver, for example, I don't know all the facts, but for example, if the harness that she was in somehow let up, well, then you've got a negligence case. Or if somebody should have been checking her for the proper height and the proper weight before she got on a ride, that's negligence against the party and the waiver wouldn't matter. So good thing to remember, you can't contract negligence. Waivers are a good idea for companies. They protect them. However, if they're negligent, that waiver, at least in our jurisdiction, is not going to hold up. So like you probably already know, don't believe everything you see in the media. We don't allow our clients to become victims of waivers. That's not how this works. They're a great idea for corporations, but they're not a catch-all. Thanks, everyone. Make sure you follow us to learn more about personal injury law.